All right, welcome back to the deep dive. Today we're taking a close look at something pretty big happening here in Virginia.
Yeah, it's a proposed law dealing with artificial intelligence.
Exactly. It's the Senate substitute for House Bill Known 2094, also known as the High Risk Artificial Intelligence Developer and Deployer Act.
Catchy title?
Definitely rolls off the tongue.
Right.
But, our listeners are here because they want to understand these complex issues, but quickly.
Right, they want to get to the heart of it without getting lost in the weeds.
Precisely. So we've got the actual Senate substitute document right here,
Yeah.
and we're going to break it down for you. We're going to figure out what this bill really means for AI right here in the Commonwealth.
That's our mission today. Think of this as your express lane to understanding how this could impact you.
Especially if you're a consumer here in Virginia. So let's jump right in. First things first, we've got to understand what they're even talking about when they say high-risk AI.
Yeah, the bill starts with a basic definition of an artificial intelligence system.
It's basically any system that uses machine learning to analyze information and then spits out outputs. Think of things like text or images, decisions, predictions, you name it.
And those outputs can have a real impact, whether it's in the real world or online.
Right, but it's important to note this doesn't include systems that are still being developed or researched. So it's really about the tech that's actually being used.
Exactly. The bill kicks in when those AI systems move out of the lab and into the real world.
Especially when they start making decisions that could have a big impact on people's lives. And that's where high-risk artificial intelligence system comes into play.
The bill says it's any AI that's designed to make or heavily influence what they call a consequential decision.
And consequential decision, that's where things get interesting. This isn't about your phone suggesting a new song.
Right, this is serious stuff. We're talking decisions with real weight, like legal or financial impacts that affect people's access to essential things.
The bill lists 9 specific categories where these consequential decisions come up. So, for instance, decisions about parole or probation, even release from prison.
You can imagine how AI might be used there for risk assessment.
Then there's access to education. AI could be involved in admissions or even deciding how resources are allocated.
And employment, too. Think AI screening resumes or conducting interviews.
Not to mention financial and lending services, loan applications, credit scoring, all that.
Access to healthcare is another big one. AI could be helping with diagnoses or treatment recommendations.
And we can't forget housing and insurance, which covers approvals and pricing, even decisions affecting marital status and access to legal services. That's a pretty wide range of areas.
Yeah, all things that have a huge impact on people's lives and their opportunities.
Absolutely. Now, the bill also makes it clear that it's not trying to regulate every piece of AI out there. It has a pretty long list of things that are not considered high-risk AI systems.
19 specific exclusions, to be exact.
So, for example, your basic anti-fraud tech that doesn't use facial recognition, that's out. Anti-malware and antivirus software, too.
Even AI video games and self-driving cars are on the list.
It seems they're really laser-focused on those big, life-altering decisions we were just talking about.
Definitely. The list goes on to exclude things like calculators, cybersecurity measures, databases, how data is stored, firewalls, domain name registration. It's a lot.
How about this one? Even how websites load in your browser.
And networking technologies, spam filters, spell-checking software, spreadsheets.
Web caching, web hosting.
Even those natural language communication tools like chatbots, as long as they have safeguards to prevent discriminatory content.
Right. All those are excluded. This really helps narrow down the scope to AI that could have a huge impact on our lives.
Exactly, the ones that could potentially cause the most harm if not used responsibly.
Now, the bill also brings up this important concept of algorithmic discrimination.
Basically, it's when an AI system ends up treating people unfairly or differently because of things like their age, race, disability, gender, religion, those protected characteristics.
So it's about making sure AI doesn't perpetuate biases that already exist in society.
But there are some exceptions. The bill says it's not discrimination if developers are using AI to test for bias and fix it.
Or if they're using it to actually promote diversity or to address past discrimination.
And actions taken by private clubs or places that aren't open to the public are also excluded.
So it seems like they're acknowledging that there are some valid reasons why AI might seem to treat people differently, but are actually for a good cause.
Right. It's all about context. Now, we've got a good grasp on what high-risk AI and consequential decisions are, but who does this bill actually apply to?
Well, there are 2 key players: the deployers And the developers.
A deployer is anyone doing business in Virginia who uses high-risk AI to make those consequential decisions within the state.
So imagine a Virginia-based company using AI to decide who gets a loan. They would be a deployer.
And a developer is someone in Virginia who creates or significantly modifies these high-risk AI systems.
Then they make those systems available for others to use, either deployers or consumers, right here in the state.
The bill also talks about what they mean by an intentional and substantial modification.
So it's not just any little tweak. It's when someone intentionally changes an AI system in a way that either creates a new risk of algorithmic discrimination,
Or if it changes the system's original purpose or how it complies with the rules.
but there are exceptions here too. Like if a deployer customizes a system for legitimate business reasons, that's okay.
As long as those changes stay within the tool's original purpose and don't increase the risk of discrimination.
And there's an exception for AI systems that continue to learn and adapt, after they've been deployed.
But only if those changes were anticipated and were part of the initial risk assessment.
So they're trying to distinguish between fundamental changes to the AI and the kind of adjustments you'd expect a learning system to make over time.
Now let's talk about the developers and their responsibilities.
The bill says developers have a reasonable duty of care.
Meaning they have to take steps to protect consumers from any known or foreseeable risks of algorithmic discrimination.
And there's a little bonus here. If developers follow all the requirements in the bill, there's a presumption that they've met this duty of care.
It offers some legal protection if there's ever any trouble.
So what are those requirements? Well, before a developer makes a high-risk AI system available, they have to provide a ton of information.
It starts with a clear statement about what the AI is intended to do. What problems is it supposed to solve?
Right. And they have to provide lots of documentation explaining any known limitations of the system, including any risks of algorithmic discrimination that they can foresee.
And they need to explain the AI's purpose, its intended benefits, how it's supposed to be used, and even summarize how they evaluated its performance before releasing it.
Transparency is key here.
Definitely. Developers also have to outline the steps they've taken to minimize those risks of discrimination.
And they need to give clear instructions on how to use the AI correctly and how to monitor it for any signs of bias.
It's all about giving the people using the AI the information they need to use it responsibly.
And it doesn't stop there. The bill also wants documentation about how the AI was evaluated, both in terms of its performance and how well it handles discrimination.
That includes describing the outputs the AI is supposed to produce, the risk mitigation measures they put in place, and very clear instructions on how to use it, especially for those consequential decisions we talked about.
And if there's any other information that would be helpful for understanding the AI and its potential risks, the developer has to provide that too.
They really have to be upfront and thorough.
Right. They also have to provide things like system cards, or like fact sheets about the AI, and any pre-deployment impact assessments they've done. Plus, they need to share their risk management policies.
It's all to help the deployers, the end users, do their own assessments, which we'll get to in a bit.
Now, there are some specific rules for high-risk generative AI. This is the kind of AI that creates things like audio, images, text, and videos.
The developers of these systems need to make sure that any synthetic content created by their AI is identifiable and detectable.
They can do that with industry-standard tools or by providing their own tools.
And the generated content needs to comply with accessibility requirements whenever possible. Plus, the identification has to happen as soon as the content is created.
This is probably to fight misinformation and to let people know when they're dealing with AI-created stuff.
Right. It's all about transparency.
But there are some exceptions. If the content is part of an artistic work or something satirical or fictional, the identification isn't as strict.
It also doesn't apply to text-based public information that's unlikely to mislead anyone.
And assistive editing tools are exempt as long as they don't fundamentally change the input or if they're used by law enforcement.
So they're trying to balance transparency with protecting creative expression and useful tools.
Exactly. Now, what happens if multiple developers contribute to a single AI system?
The bill makes it clear that each developer is only responsible for the parts they created. They're not on the hook for the whole thing.
And if a developer makes a big change to a system after it's released, what the bill calls an intentional and substantial modification.
They have to update all the disclosures and documentation within 90 days.
Keeps everything accurate and up to date.
Absolutely. And to be fair, developers aren't being asked to spill all their secrets.
They don't have to reveal trade secrets, sensitive security information, or anything else that's legally protected.
And there's an interesting provision here. If a system is developed according to standards like the NIST AI Risk Management Framework or the ISO IE 42001 standard.
The developer gets a presumption of conformity with the Virginia bill.
So basically, they're encouraging developers to follow those established best practices.
Now let's switch gears and talk about the deployers, the ones actually using these systems to make decisions,
They have a reasonable duty of care, too.
just like developers.
Yeah.
And they also get a presumption of compliance if they follow the rules.
One of the big requirements for deployers is that they have to have a risk management policy and program in place.
And they need one for every high-risk AI system they use for consequential decisions.
This policy needs to explain how they'll identify, mitigate, and document any foreseeable risks of algorithmic discrimination.
It's all about having a plan to use AI responsibly.
And this policy should be based on the latest guidelines from NIST or ISO IX 42001 or something similar.
If they follow those standards, they get that presumption of conformity again. Seems like they really want folks to follow best practices.
Now, maybe the biggest responsibility for deployers is the impact assessment.
They have to do this before they deploy a high-risk AI for consequential decisions, and again, before any major updates to the system.
This assessment is pretty in-depth. They have to start by stating the AI's purpose, how they plan to use it, the context, and the expected benefits.
And crucially, they need to address any foreseeable risks of algorithmic discrimination.
They have to describe those risks and how they'll mitigate them.
They also need to check if any new ways they're using the AI are still in line with the developer's original intentions.
And they have to describe the data the AI uses, both as input and output. If they've used any extra data to customize the system, they need to explain that too.
They also need to list how they're measuring the AI's performance and any limitations it might have.
And they need to describe any transparency measures they're using, including how they'll tell consumers they're interacting with an AI.
Finally, they have to explain their plans for monitoring the AI and any safeguards they have for users.
The assessment also needs an analysis of the AI's validity and reliability based on industry standards.
It's a lot of work, but there are some practical considerations. For example, one impact assessment might cover a group of similar AI systems.
And if they've already done a similar assessment for another law, they might be able to use that.
And they have to keep all these assessments and records for at least 3 years.
Now, when a deployer uses AI to interact with a consumer, there are even more disclosure requirements.
They have to tell the consumer that they're interacting with AI.
And they have to disclose the AI's purpose, what kind of decision it's helping to make, the deployer's contact info, and a plain language explanation of how the AI works.
They need to explain what the AI measures, how it measures it, and how that's relevant to the decisions being made.
They also have to explain whether humans are involved and how the automated parts of the AI contribute to the final decision.
What happens if a deployer uses AI to make a decision that negatively impacts a consumer, and that decision is based on data the consumer didn't provide?
The deployer has to tell a consumer about the decision quickly and explain why they made it.
That includes explaining how the AI was involved, what kind of data it used, and where that data came from.
And they have to give the consumer a chance to correct any inaccuracies in their data, according to the Virginia Consumer Data Protection Act.
And they have to let the consumer appeal the decision and have it reviewed by a human, as long as it's technically reasonable and in the consumer's best interest.
Of course, there are exceptions, like if a delay would put the consumer's safety at risk.
Deployers also have to make a clear statement summarizing how they manage the risks of algorithmic discrimination.
And, like developers, they need to update their disclosures and impact assessments within 30 days if the developer makes a significant change to the AI system.
And if the deployer makes a significant change to the AI, they actually take on some of the developer's responsibilities.
They have to follow the same documentation and disclosure rules.
And again, they don't have to reveal any trade secrets or legally protected information.
Okay, we've covered the definitions and the responsibilities. Now, what about exceptions? Are there any situations where these rules don't apply?
You bet. There are a lot of exemptions in this bill. They've tried to think of all the situations where these regulations might not be necessary.
For instance, if a company has to do something to comply with other laws or regulations, that's exempt.
Like if they're responding to a subpoena or cooperating with law enforcement.
Or if they're defending themselves against a lawsuit.
And if they're doing something specifically at the request of a consumer, like fulfilling a contract, that's exempt too.
And anything they do to protect someone's life or safety is exempt as well.
like preventing fraud or harassment.
Or dealing with child sexual abuse material.
Public or peer-reviewed research is also exempt, as long as it follows ethical guidelines.
Interestingly, if a developer or deployer is helping someone else comply with this chapter, that's exempt too.
And actions taken in the public interest for health reasons are also exempt, as long as there are safeguards in place.
They've also exempted internal research and development activities, product recalls, fixing technical errors, and using AI for internal operations that are in line with consumer expectations.
And as we mentioned, there's no requirement to disclose trade secrets or legally protected information.
And they don't have to do anything that would violate legal privileges.
There's even an exemption if following the rules would interfere with someone's free speech or freedom of the press.
And AI systems acquired by the federal government are conditionally exempt, but this doesn't apply to AI used for employment or housing decisions.
Regulated financial institutions like banks and credit unions are also exempt, as long as they're following guidance from regulators on high-risk AI.
Same goes for regulated insurance companies if they're supervised by the State Corporation Commission or a similar federal body.
AI systems used only for testing in a controlled environment are also exempt.
And systems that have been approved or certified by a federal agency or meet federal standards that are just as strict as this bill are also exempt.
They even exempt telehealth services and HIA-covered entities using AI for recommendations or certain administrative functions.
It's important to remember, though, that if a developer or deployer wants to use one of these exemptions, they have to prove that it applies to them.
And if they withhold information based on an exemption, they have to tell the person affected and explain why.
Now, let's talk about enforcement. Who makes sure everyone is following the rules?
The Attorney General of Virginia is the one in charge of enforcing this bill.
They can issue something called a civil investigative demand, which is like a subpoena to get information if they think someone might be breaking the rules.
And when companies respond to these demands, they can redact trade secrets and other confidential stuff, but they have to explain why they're doing it.
Importantly, any information given to the Attorney General during an investigation is exempt from the Freedom of Information Act.
So companies don't have to worry about their secrets becoming public.
The Attorney General can also go to court and get an injunction to stop someone from violating the bill.
And if a court finds that someone did break the rules, there are penalties.
It can be up to $1,000 for each violation, plus the costs of the investigation.
And if they did it on purpose, the penalty can be as high as $10,000 per violation, plus costs.
And every single instance of non-compliance can be a separate violation, so the penalties can really add up.
The Attorney General can also demand to see any documents related to this bill, like impact assessments and risk management policies.
But there is a way for companies to avoid penalties.
If they discover a violation themselves, fix it within 45 days and tell the Attorney General about it, they might be off the hook.
And before taking any action, the Attorney General has to talk to the company and see if they can work things out without going to court.
They can even give the company a 45-day notice to fix the problem.
But there's one really important thing for people to know. This bill doesn't give individuals the right to sue companies for violating it.
So if you think a company has done something wrong, you can't sue them yourself. Only the Attorney General can take action.
Now, for some general provisions to clarify things. The bill says its main purpose is to protect consumers and make sure they know about important decisions that affect them.
So anything in the bill that gives rights or protections to consumers should be interpreted broadly.
And any exceptions to those protections should be interpreted narrowly.
There's also a severability clause. If one part of the bill is found to be invalid, the rest of it still holds up.
And the bill goes into effect on July 1st, 2026, giving businesses time to prepare.
Importantly, complying with this new bill doesn't let anyone off the hook for things they did before it went into effect.
And it doesn't change any existing legal claims that people might have.
So, to sum it up, this bill in Virginia is a big step towards regulating high-risk AI, especially when it's used for those big decisions that affect our lives.
It puts specific responsibilities on the people who create and use AI, and it's all about mitigating discrimination and making sure consumers are informed.
If you're a consumer in Virginia, this bill could mean you'll have more transparency about how AI is being used to make decisions about you.
You have the right to know why a decision went against you, and you might even be able to appeal that decision.
If you're interested in learning more, look up the full text of HB 2094 S1 on the Virginia General Assembly's website.
And keep an eye on any updates as things could change as it goes through the legislative process.
So we've got a lot to think about here. This bill is trying to strike a balance between promoting AI innovation and protecting people's rights.
It raises a lot of questions about the future of AI and how we'll regulate it as it becomes more and more a part of our lives.
That's it for the Deep Dive today. Thanks for joining us.
Until next time.